begin. So committee, also just to let the public know, we will give an opportunity at the end of the meeting for 15 minutes for the public to comment to the committee members at that time. So I'm going to kick off the meeting. And Owen, if you could please let everybody in. Thank you. So, committee members, have you had a chance to look at the draft agenda? Here it is. Hopefully you can see it on the screen. And if the agenda looks good to you, if somebody can get, Eric, I can see you. So can you give me a thumbs up if everybody thinks that's looks appropriate?
It looks fine to me based on our discussion at the last meeting.
Great, thank you so much. And I'm assuming that others also approve of that. So I will move to the meeting minutes. And so here's the meeting minutes. I'll give you an opportunity to review those in case you have not been able to so far. So some of those definitions ended up in the final report, so we will review that later. Okay. I see if Eric and Amy, you're in there, and so is Sarah. Bill, did you have any questions about the meeting minutes?
No.
Okay. Would somebody like to make a motion to accept the meeting minutes, please?
I move we accept the minutes.
I'll second. All those in favor, say aye.
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 Any nays?
Although I do have a question in reviewing the minutes again, and I was wondering about our agenda. A number of people asked to speak, to have time on the agenda in a more formal way. How are we accommodating that request?
I believe in the beginning of the meetings, we decided that we would not allow the public to have more time until we got the draft report together. So I believe that's what the committee members decided. And if we have time at the end of the session after the draft is completed, then we can revisit that. So if you'd like to revisit that now, we can do so, Amy.
Well, I just want to, is that how we left it with them? So it was VNRC, the Federation of
Vermont Lakes and Ponds.
Yeah, wonder, and the others may have asked as well, but I don't know, whatever. Did we respond to them?
So I believe we were going to talk about that now and or in the future when we had time and we knew that the report was full and ready to be submitted. But I know that we had a quick turnaround time to get this report developed, and having public comments included in the report and then also responding to those public comments would lengthen the process. So I believe that the committee members, and please members, let me know if you feel differently, that we agreed that we would allow the legislative committee who takes this on to then consider any public comments.
Yeah, that was my understanding.
Eric, do you have any comments about that?
Yeah, similar to you and Bill, I know we talked about the fact that the legislative process itself was open to public input, public comment. I didn't know whether we resolved whether we weren't going to have an opportunity for folks to provide more involved kind of comments or discussion. But I know that we wanted to focus on getting the draft done as quickly as possible because of the limited time frame. So yeah, like Amy, I'm not exactly sure where we ended up on allowing further public discussion or comment. But we didn't build it into any of our, future agenda topics. So if we want to, I guess now would be the time to discuss that. I
Yes.
feel like it'd be nice to have Sarah here because she was the one who was feeling the most significant time pressure for her internal review process at Department of Health.
We can wait till Sarah gets here, if you like. And in the meantime, we can accept the meeting minutes and then move on to the agenda items. And then we can, let's see, we can add that in at 2 o'clock. Oh, I keep I keep ending things a little bit earlier, so we do have 15 minutes to talk about that. So we could always include public comments and how to have them present in the future meeting at 2:15.
Okay, that's good for me. Thanks.
Okay, sure. So I'm going to add that as an agenda item then. Okay, so now we have 15 minutes to discuss the public comments in future meetings. Does that sound appropriate?
Yep.
Great, thank you. Okay, so does everyone accept the meeting minutes? Please say aye.
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 Any
Aye.
nays? Hearing no nays, we've accepted the meeting minutes from October 17th, 2023. Okay, thank you. So the next item is to review and discuss the aquatic nuisance control permit conditions for public notice, which is under Title 10-7714. And I'm going to give the floor to Olin to present that information for us. Olin, are you all set?
Yep.
Great.
Yep,
Thank you.
sure.
Bob, can you please turn off your camera?
Yes, I can.
Thank you. I appreciate that.
All right, so everybody can see the PowerPoint that's up right now.
Yes.
Great, awesome. All right, so we're gonna kind of go over a bit about the aquatic nuisance control public notification and where it stands in our statute, as well as where it stands in Title 10, Chapter 170. So in 10 VSA 1455, in the aquatic nuisance control permitting statute, substatute H calls out when an application is filed under this section that the secretary shall proceed in accordance with Chapter 170. So that's how the current statute under review in Chapter 50 is connected with the public notification process that's found within Title 10. And so we're going to talk about a few different things. We have 3 different types of procedures, and we've kind of mentioned this in the past meetings. And so I'm going to go into these a bit more in depth, but just as a quick overview, we have 3 types of procedures. You can see that aquatic nuisance control permitting is a type 3 procedure. And again, I'm going to go into more depth about these, but it's a type 3 procedure. And that again is found in 10 VSA 7714. We also have type 2 procedures. And so you can see that I've highlighted lake encroachment and individual shoreline permits. Those are both type 2 procedures, and they differ from type 3 procedures in that they have a little more public notice requirements. And again, I'll go much more into depth in a bit. And then we also have type 1 procedures. Type 1 procedures are our most involved type of procedures. They're for individual permits under the Clean Air Act and Clean Water Act. So they're mostly federal permits. They're a little bit outside of the scope of aquatic nuisance control permitting, but that is what type 1 procedures are. And so type 3 procedures, this is under 10 VSA 7714, just as a little background as to what we're going to be looking at and what is currently required by statute for public notice. So you can see here, notice of application. So the secretary shall provide notice of an administratively complete application. And I'll kind of talk about what that means. And then notice of a draft decision. So that's when a draft decision is made by the program. The secretary shall provide a public comment period. And then a public meeting. So whenever any person files a written request for such a meeting, the secretary may also hold public meetings at our discretion. So we do have the option to just hold public meetings in preparation for comments. And then notice of final decision. So whenever a final decision is reached, we are required to provide public notice. And then with this, there's been some miscommunication on this, and I just want to make this clear. That we are required by statute to provide responses to comments received during the public comment period. So we do respond to all comments, and I'll give some examples of what those look like later on. Does anybody have any questions so far about this? And I can't see anybody, so if you do, just please speak up. Okay. Hearing none. I'm just going to kind of go through Title 10, Chapter 170. And so in 10 VSA 7701, that's just the standard procedure, and it talks about the purpose of the chapter. And so the purpose of this entire chapter is just to establish standard procedures for public notice, public meetings, decisions, that sort of thing through the Department of Environmental Conservation. And then we're going to go through a couple definitions that I'm going to talk about more. And so you might hear these, and I just want to make sure we're all on the same page when I do mention them. So adjoining property owners. So these are people who abut any project boundary. So within a lake, it may be any lake shore owner. And that might be what is considered an adjoining property owner, depending on the project type. Administratively complete applications. Whenever a application comes in, it is initially reviewed by the BOSS program, which is within the Watershed Management Division. And then they just check to make sure that signatures are there, fees are paid, that sort of thing. But this does trigger a notification. So I just want to make sure that we understand what that administratively complete application means. And then what the environmental notice bulletin is. So it's our website and email notification that's required by 3 VSA 2826. And then again,
can we go
go
back for 1 sec? The previous slide, is this all types, all 3 levels, or is this
yes.
just?
Yeah.
So you said someone else on a lake or a pond might be considered adjacent. Are they or aren't they? Because this refers to river, not lake or pond.
Yeah. So when we look at this, it shares a property boundary with a tract of land where proposed or actual activity regulated by the department is located. So in that, if a project were to occur on a lake, because everybody along any shoreline owner abuts that body of water, we would then require notification for those people, since they're all abutting that body of water.
Okay, so that you notify them all.
Yes. Yeah.
Thank you.
Olin, I just want to clarify that, again, sea lamprey control treatments are a little bit unusual compared to most of what we're talking about, but we obviously aren't asking the U.S. Fish and Wildlife Service to notify everybody around Lake Champlain
Right.
when a treatment occurs. So there's a expected zone off the mouth of the river where the treatment concentration would drop to below a normal detection level, and shoreline notification only extends to that zone.
Eric, do you know what that zone is? How far out?
It varies river by river, and it's based on some modeling of normal lake flows, wind conditions, and it's basically like a worst case scenario of how far it could go in either direction, up or down the shore, and that's where the notification extends. But it's based on some dye studies and modeling that's done river by river for the rivers that receive TFM treatments.
Thank you.
Yeah, thanks for bringing that up too, Eric. Yeah, that is correct. So yeah, any project where it may be impacting those people is a better way, I guess, to say that than so yeah, with Lake Champlain, it's not everybody within the lake. It's a huge lake, obviously. It's just people. I think the most recent treatment that occurred, it was everybody within that southern bay off of the Poltey River. And so that's kind of how that works. And after that, it's like Eric said, it's non-detect levels. So people are not notified outside of that bay based on the modeling that's been done. And so then just quick definition of permit. So it's just a form of permission required from the department by law. So that's a pretty basic definition. Persons. So we've talked about this a bit in the past, but the definition of person actually comes from 10 VSA 8502 in this instance. And so a person means any individual, partnership, company, corporation, association, joint venture, trust, municipality, the state of Vermont, or any agency, department, or subdivision of the state, any federal agency, or any other legal or commercial entity. So whenever we talk about person in this statute, this is what we're referring to. And then public meetings are meetings that are open to the public. Again, they're recorded and transcribed by the department. Sometimes we allow requests for public meetings, and sometimes we've also just held those public meetings in anticipation of comments. I think though our last public meeting that we held in anticipation of comments, I think Eric was our only person that showed up. So we haven't done one in a couple of years, but again, it's something that we're always prepared to do. And then technical review and technically complete applications. This is what I do. So I do the scientific review of applications. So whenever we talk about technically complete applications, it's after I have compiled all of our internal review procedure comments, and then gone through any other comments and projects and done the whole scientific study of an application. All right, so then 7703, 10 VSA 7703, this is the next substatute. And this is going to kind of go into a bit more about our rules and implementing rules. So we can see here that there are complex projects, and so we can adopt rules to determine when a project requiring it to be large or complex. And you can see again that we call out adjoining property owners, the environmental notice bulletin, and adjoining property owners, and informing them on how they can continue to receive notifications. Within this, as a continued section, I'm going to call out this statute here that's highlighted. I'm going to come back to this again and again throughout this presentation. So I just kind of want to give it a once over here. And so this is an additional notice. And so the secretary may require by rule or in an individual case measures in addition to those directed by this chapter using any method reasonably calculated to give direct notice. And this is kind of the big part here, is to persons potentially affected by a decision on the application. So we are allowed by statute to require additional notices if we deem them reasonable and necessary. And so again, I'm going to come back to this, but I just wanted to call it out here. All right, and so then this is just the standard procedure of what the notification process might look like. So whenever a new application comes in, there's notice through the environmental notice bulletin. So this is kind of what an email may look like. This is after an application's been technically reviewed, but they look very similar for any of the notices that are sent out. So it's any person that requires notice under section 7712, the applicant, everybody on the interested persons list, the municipality, and to any other people that the chapter refers to. So again, these are, if you subscribe to the environmental notice bulletin, you would get this email whenever an application comes in for a lake that you may be subscribed to, whenever the project is administratively complete, whenever it's going on draft for the comment period, and whenever a final decision is reached. And then this is everything that the environmental notice bulletin, actual bulletin, shall contain. And so instead of reading through all of this, I'll just show you what it looks like. So this is for a current project that is on the environmental notice bulletin. This is an application to use DASH to control EWM, or Eurasian water milfoil, in Lake Memphremagog. So this is currently on the environmental notice bulletin. You can go look it up by the permit number or the ID, which is 4090. And you could make a comment on it. So you can see here that the activity type is required, the application, where it's going to be taking place, a brief description, when the application was received, draft decisions, when the comment period starts and when the comment period ends. There's a map that's provided. My contact information is there. And then there are all the documents that are related to this project. So the draft decision as written, as well as the updated application, are both included. And then there at the bottom left, there are instructions on how to request a public meeting if necessary. So again, if anybody here would like to comment on this project, feel free to. This is where you find that information.
Well, may I interrupt you for 1 second? John, can you please turn off your camera? Thank you. Go ahead, on. Thank you.
And so then other things within 10 VSA 7711, this defines comment period length. So you can see that comment period is at least 30 days. That can be extended, but we generally stick to 30 days within aquatic nuisance control permitting. It also defines the period to request a public meeting. So you can see that requests have to be within 14 days of the date on which notice of the draft decision is posted. And then again, it talks a little bit about draft decisions. So it defines what that is and who should be, and the instructions that go along with that. From there, again, it talks, or it defines response to comments. And so here it mentions that the secretary shall provide a response to each comment received during the comment period and the basis for that response. So the secretary shall also specify each provision of the draft decision that has been changed in the final decision and the reason for that change. And then within that final decision, we send that to everybody who has requested it and whoever is going to be impacted by it. And then as well as the response to all of the comments shall be sent to all people that sent in comments. And so this is what a comment piece of work looks like. So you can see this is from our most recent pesticide project. So this is actually for the Poultney and Hubbardton Rivers in West Haven. And so you can see that a comment was made by U.S. Fish and Wildlife Services in their application. They had not requested a flow limit. And so a flow limit was made in the draft decision by our program, but they actually wanted to request a higher flow limit. And so they made a comment during this public comment period. And then we reviewed this comment based on previous permits that had been approved. So permit number 2015-C06 was their most recent permit for this exact river. And so based on the permit conditions from that permit, we updated the condition to match that so that it was consistent along the years. That's how a comment document works. These can be very long depending on the project type. Sometimes we receive 50 comments, and then our responses to those comments can be 2 to 3 pages each. They can be incredibly lengthy documents. I'm not going to make us all read through one of those. But if you would like to see one, again, they are all public. And if you would like to see one, I'm more than happy to send one out.
We could include one in the working documents or in the files.
There is one in the files.
Yeah.
I don't remember what project it was for, but I believe there is one in the files. And if not, I will add one. That's a good idea. And so again, I'm going to come back to this statute that I mentioned I was going to come back to. So the secretary may require by rule to add additional notice, and that's to persons potentially affected by a decision on the application. So we felt whenever this, whenever Title 10, Chapter 170 was passed, I believe it was in 2018, that we could go a little bit further to provide more notice to people that were potentially impacted by projects on lakes. And so this is where we gained that statutory authority. And so we created this. And so what we've done is we've essentially made what is a Type 3 procedure for aquatic nuisance control into a Type 2 procedure. So we require, not through statute, but by rule, adjoining property owners to be notified. So, and that's during an application. So this is what we call our adjoining property owner notification guide. So whenever, as part of submitting an administratively complete aquatic nuisance control permit application, you have to follow this guide. And for pesticide or chemicals, you have to inform or notify any property owner that abuts that lake section, or surface water where the proposed activity may occur. And then in addition, property owners that abut the surface water receiving effluent that may potentially be affected by a decision on the application. So what that ends up looking like is we require all property owners that abut a body of water to be notified, as well as those 1 mile downstream. And that's how that works. And then in the case of Lampricide projects, we base that downstream decision on whatever dive studies have been completed by U.S. Fish and Wildlife. And this is what they look like. It has the property owner or the applicant name, the proposed activity, and how to go look at all of the materials that are relevant. So they can go look at the application, and they can go look at and subscribe to it so that they can see when a draft decision is made, when the comment period opens up, and when a final decision is made. So that's what this official notice looks like. And again, it is required to be sent by U.S. mail. So we do follow that standard. And so this is where Type 2 procedures and Type 3 procedures differ. So again, if you look at the Type 3 procedure, notice of application, it's just the secretary shall provide notice of an administratively complete application through the environmental notice bulletin. But if you look at a Type 2 procedure, you can see there's an extra thing here that says the applicant shall provide notice of the application to adjoining property owners. So again, we felt that aquatic nuisance control permits should also be required to provide notice of application to adjoining property owners. And so through that statute that I called out earlier, we then required this to be done as well for aquatic nuisance control permitting. And so essentially what we've taken, again, a Type 3 permit or a Type 3 procedure and made it into a Type 2 procedure through rule. And then on top of that, we also have notification requirements within the condition that are not called out in statute at all. And so this is just, this is from our most recent herbicide permit. So this is 3955 A and C. So this was an application, or is a permit to use Procelicor on Salem Lake. And so this was approved, I believe in July was the final decision, or early September. And this is what another notice condition looks like within the permit. And so this is part of that project. So whenever a application of or a treatment is scheduled, they have to provide public notice at least 30 days in advance. And that includes a website and physical postings along for at least 30 days in advance, as well as maintaining those 30 days post-treatment. And so that notification includes a map, scheduled treatment dates, the pesticide that's being used, any contact information that may be useful, the web page, any water use advisories and recommendations, and then a statement identifying that the permittee shall also supply potable water upon request to any of those that request it. And then a statement informing all property owners that if their property is leased or rented, that they have to notify the tenants. With that, the notification shall also be provided to the secretary. So it comes into my office, I approve it, and then it goes into the municipal offices. So in this case, Derby, and then all, again, owners that abut the lake, and then those that are receiving effluent up to 1 mile downstream. Again, physical copies are required, so those are in visible or locations visible to vehicle traffic. So they're usually along roadsides. They have to be on weather-resistant material, and then they're also at all public access points to the water bodies. So things like boat launches, public beaches, and other, if there's a public camp or something like that, then they all have to be posted there. With
So,
that,
go
ahead.
I just am curious, the distinction here is, I just need clarification. So notification of the permit application versus notification of the permit approval, all of the type 2 changes, I think they're referring to after it's approved, or is it for both?
So we go back. This is the only difference between type 2 and type 3 procedures in the application notification process. So type 2 procedures are just required to provide notice of application to adjoining property owners. That's the difference between type 2 and type 3.
Okay, but application means after they have the approval to apply the pesticide, not applying for a permit.
So this is notice of application of the permit. So they're applying for a permit. So whenever Salem Lake, for instance, 3955, this is our most recent one, whenever they applied to have a permit for the use of Procelicor in their lake, they had to provide notice to all adjoining property owners as part of their complete application process. So this was before it had been, this was before the project had been technically reviewed. So they were letting everybody know that they were applying to do this.
Yeah, and then do they get notification after the approval?
Yes. So if they want to, if the public wants to sign up, that's what was it? This. This is how the public can then also sign up for notifications for when the project has a draft decision, when the comment period is, if any public meetings are going to be held, and then when a final decision is met. So this is when this is the piece of paper that shows all people that are adjoining property owners how to sign up for those notifications. But there's not a in the application process, there's not another section that requires them to notify the public outside of the environmental notice bulletin.
Okay. And then how often does a permit is it not granted for Procelicor?
So we've had 13 applications since 2018. We've approved 11 and denied 2.
Thank you.
Mm-hmm. So going back to this is what these notices look like. This is what's required. So you can see that this map shows the treatment areas, and then it also gives you the lake water advisory use recommendations. There's the contact information for any questions. There's a link to the website. Again, this is posted in all public places. It's usually along roadsides and all the boat launches, all those sort of things. And it's usually both copies of this that are sent there. Depends on the actual notice. This is from a specific company, but U.S. Fish and Wildlife's look a little different. But they all contain the same basic information and the same links. They all maintain websites and that sort of thing. So yeah, that's kind of the end of the presentation. Then I've got some discussion points here. So I just wanted to talk about whether or not the committee feels that the DEC's approach to make these determinations, is it adequate, if it's lacking, where could things be added? I don't know if anybody from the committee has thoughts on that.
'Cause I
Bill,
feel-
you have a question?
Yeah, I just wanted to know, is the town health officer no under these circumstances?
Just the municipality. It's called out as the municipality, not necessarily the town health officer.
Because they could be useful in locating people who might fall between the cracks.
That's a great thought. And I guess it would be our assumption that the municipality would work with the town health officer, but if that's again something that we feel needs to be called out, that's something we can call out.
Eric?
Yeah, just an observation, having looked at a lot of these, is I think that once you navigate your way to the environmental notice bulletin and know what name to search for, there's a ton of really helpful information here. I think part of the gap is that unless you know that something is in the works, it wouldn't necessarily come out and get flagged to you. It's sort of when we're reviewing permits, we have to know that there's an application in process and then go and kind of search our way through the environmental notice bulletin to find it, which you know, we're good at that, but it might be challenging for some member of the general public to know that they even needed to go and look in the first place. But it's a balancing act. Fish and Wildlife is doing tons of public notice and spending, thousands of dollars to try and put notices in newspapers, and we still oftentimes have public hearings that nobody shows up to. So it's hard to strike the right balance in how much public notice to put out.
And it-
would
Go
it be
ahead.
possible, I'm just thinking about other people who care about a body of water, like putting it at boat launches and beaches.
Well, and yeah, they are. I mean, they are required that part of that application, the part of the piece. We can go back here. I can show it here. In this part, yeah. So here, I mean, once an application has been approved, and they are then requesting to do treatment, that treatment is required to be at public boat launches, public beaches.
Yeah, but I'm thinking
But I can
getting
understand, right? Yeah.
in advance before.
And it should also be noted that it was much prior to my time, and I believe also prior to my predecessor's time, so it's been at least two people back. Aquatic nuisance control permits did seek notifications or request notifications in things like newspapers, and local municipality and that sort of thing. I don't know why that changed, other than this chapter being written and signed. But then again, this is years ago, at least in the mid 2000s. But so that's something that used to be required and has kind of seems to have fallen off the wayside. Because again, it's only called out in type 1 procedures for that sort of notice. It's not called out anywhere else. So yeah, then I guess if there are other thoughts about maybe there being other criteria, or whether or not aquatic nuisance control permitting should be a different type within statute rather than through rule like we currently are doing within the program.
It's through statute, not rule.
Or yes, yeah, sorry.
So, Amy, not to call you out, but I know that you did include some information in the draft report about utilizing some of that type 1 information. Do you have any other comments, other than what was in the draft report?
Well,
Including information.
Well, I guess I just keep going back to the fact that these are the waters of the state of Vermont, and that I'm not sure we're really meeting folks who may have an interest in this type of, you know, in the application of a pesticide, when we're only really getting in touch with people who own property around it. And I think we should be addressing that, and that the public, it's very hard, like as Eric just pointed out, it's hard for someone who uses the environmental bulletin. It's hard, it's a heavy lift to expect the public to be monitoring the environmental notice bulletin.
Hannah, you have a comment?
I actually have a question, because the environmental notice bulletin is not something I deal with directly, but I know that you can sign up for alerts related to specific projects. Can you sign up for alerts based on location or because I know that often lakeshore landowners they don't always live in the state full time. So can you sign up for notifications based on location?
Yes, yeah, you should be able to sign up for that. I believe you can sign up for like, I'm not subscribed to any of them, but you can, I believe you can sign up for like certain types of projects within municipalities or within counties even. So you should be able to see what's going on in your local area.
Okay,
There
and
are
then
a
you
lot of
would,
things that get posted to the environmental notice bulletin, so you should be able to set filters for that. And I'm sure not everybody wants to see every septic, application that comes through, but for larger applications like this.
right,
Yeah,
okay.
I also know that you can search just under aquatic nuisance control.
Yep.
So you can get all of the notices for aquatic nuisance control projects. That's what I have under mine. I get to view all of them.
Okay. So there are ways to filter that, and you would then get email notification when things popped up, when applications were filed.
That's correct, yeah.
Okay.
So there is, yeah, so I think the challenge is that we have a process that's, available. Yes, it's difficult to know that process exists. Perhaps posting information at municipalities, town halls that may have lakes. Perhaps we can have some sort of poster made or some kind of outreach brochure that people would know that. I think that's, the challenge that we have just in the Lakes and Ponds program is that we don't have like an outreach person. It's basically scientists doing that outreach and, designing web pages or, doing our web pages. And so we have a lot of tasks that we have to do. So I think that's something that can be done, however, because that is under our responsibility with the Aquatic Nuisance Control Program, is to develop outreach materials.
Well, it seems like the applicant's required to notify the adjacent landowners, right? So they could, maybe it would make sense for the select boards in the towns. Are they on that list? I mean, and then a notification at the boat launches and public access areas. I mean, that's a little awkward because you might apply in the winter when people aren't using them, but if it goes to the towns as well as is publicly noticed so that folks who are using that body of water regularly have notice, that would be a big improvement, I would think.
Yeah, I think we can work with, Eric with Fish and Wildlife. They are in charge of the access areas and the signage. So, we can certainly request that to, have a space on their limited space of billboards to post that kind of information, and also at municipalities too.
I mean, the post on Front Porch Forum is pretty easy.
Yeah, I guess I would like clarity on who is going to do that. Is that going to be, the Aquatic Nuisance Control Program? Is that going to be the applicants? How do we make sure that there's a system of checks and balances and also responsibilities?
How do you check now that an applicant has met their notification requirements?
Sure. We can request proof that they've done it. We have never had to do it, but we know that it does happen. And so it doesn't have to be certified mail. So it doesn't go through certified mail. So there's not a signature that happens proving that somebody's gotten it. But that is, again, a limitation of staffing more than anything. It's hard to certify something like that whenever we don't have time to do that. But again, it's not an issue that we've ever had come up. If it was, if somebody was to complain or something like that, bring to our attention that something was not done, then we could then request proof. I'm not sure how we would do it. We'd have to work with probably with Hannah and others to figure that out. It's not something I know that has come up anytime recently.
Eric, you had your hand up briefly. Are you all set?
I was just gonna kind of emphasize what was pointed out earlier, that a lot of times these applications are coming in the winter, so putting some sort of a paper notice up at a Fish and Wildlife fishing access area may not be that effective. What we've mostly gone to is more social media approaches using Facebook, Front Porch Forum. We have 2 of our department-owned Facebook pages, and we find that tends to be more effective at getting outreach out rather than paper approaches, including, the old newspaper public notices that used to be the norm. But still, there's that question of how do you most effectively reach people, and most lake associations who are applying may not attract a lot of folks to their Facebook page other than other association members.
Mhm.
Does DEC have that same outward face?
So we do, but we also have to work in competition with other divisions and departments. So we're pretty limited to what we can post on social media.
I don't know what that means, in competition with them.
With other, like with drinking water and, with stormwater. So everybody wants to post something on social media. So that's what we're challenged by, but certainly we can make that a priority if that is what the committee decides should be a recommendation. And then I guess I would want to make sure that we define those boundaries. So that is that for all aquatic nuisance control practices or permits, or is that just for pesticide applications?
Mm-hmm.
So is that a recommendation the committee members would like to have, is to have a social media posting about these these herbicide treatments or pesticide treatments, I should say?
I mean, I would propose that we recommend that that we pursue more broad postings of notification of permits, as well as application, I guess, although, yes, and of application. And then I think it's worth considering the use of social media or Front Porch Forum, both.
Okay.
I assume your question wasn't rhetorical about, is this for all practices or pesticides? My assumption was we're really focused on pesticide use for the public notice, not so much bottom barriers or diver-assisted suction harvesting.
Mm-hmm.
And again, sea lamprey control is a whole different animal and is already required to send out media releases to all of the area newspapers and TV stations. I don't think we'd want to go to that level with individual, lake associations. So I think in in a lot of cases, what we're talking about is really more the like milfoil control activities and how to get better notice out for those.
Mm-hmm. Yeah, and we can make that a responsibility of the applicant as well.
Yep.
And I believe, in my experience, not all lake associations do, but I think most lake associations, that's a recommendation that we provide to them when we're just in the discussion mode about what practices can be used, and to make sure that they talk to their community members before you do apply. So we have a lot of discussions before they even apply. So we really do recommend that they reach out to landowners and reach out to their community members and reach out to their municipalities before they take or before they apply for an aquatic nuisance control permit.
I'm not sure
So
how
I
to capture it, but I feel like there's also a difference between like a first time treatment and a new water body versus maybe the 10th time that the same activity is occurring. And I'm not sure how best to parse that out, but certainly if it's the first time a lake is proposed for treatment, folks may be far less aware of that.
Mm-hmm.
Oh, all right. So Eric, just so I understand what you're saying, you mean that there's some more broadly, people are paying attention more in a lake that's already gone through it?
Yeah, my thought was that for a lake like St. Catherine that's been treated multiple times, that I think there's general awareness of that practice on that water body, not just from lakefront property owners, but from the broader public. Whereas I think the proposal to treat bombazine caught some folks by surprise as a somewhat new approach. Not that bombazine hasn't had milfoil control in other ways in the past, but not with lake-wide herbicide treatment. So just trying to differentiate that. I think getting the word out for the first time a water body is proposed for treatment, like Salem Lake this year, may merit some additional outreach efforts.
Yeah, and I will say with Salem Lake, it was a new infestation. And they did explore all the non-herbicide, practices, really trying to eradicate that new infestation. We did have a conversation, DC had a conversation with the Lake Association and with the municipalities because they were exploring the option to use herbicide. So I think it was 2 years ago, we had that conversation with the Lake Association to be sure to talk to the landowners and to the municipalities and to show up at town meeting day and to really try to inform the local community. But I guess that's not a requirement, it's just an ask.
And part of that too, it can be added within the permit conditions. Once a permit's been approved, that could then be within those conditions that I showed earlier, for specifically for lakes that have been treated, for treatment, upcoming treatment whenever other public notice occurs. So that could certainly be added to our condition if that's something that everyone was felt was necessary.
Can you say that again? I'm not sure I followed what you were saying.
Sure. Yeah, like Eric was saying, with lakes that have gone through these processes a couple times, with things like Lake St. Catherine versus Lake Bombazine, which was a new application. When a project changes like that, we can in our permit conditions, we can require for an approved application, we can require notification every time that a lake wants to treat with Priscillacor or whatever the approved herbicide is. So that's something that could change within our permit conditions, whether that be the addition of like notification to a newspaper or something like that. That could be changed as well. Or like Bill was mentioning, the public health officer, if we specifically want to call out a public health officer, rather than just municipalities as a broad whole.
So you're saying that the permits that are already permitted, we can add that as a condition in the future. And we can add it now in the permit condition. Because the permit conditions, we can add as we, as we see fit. And so that's, that's what Olin is trying to explain, is that we can add that now in new permit conditions that for applications that are coming on, or for those activities that are already permitted.
I think, yeah, that's fine. I think, again, part of the gap is those permit applications where a permit has not been issued, and how do people get some notification that something is being proposed while it's still in the application review phase. I think once a permit is issued, it's easy to put conditions in there for public notice requirements. It's while it's still in the application phase that, folks may be far more interested in learning and getting engaged at that point, but we don't necessarily have a good venue for getting the word out.
Right.
And I'll, with that, I mean, again, the addition of the adjoining property owner notification, that is not part of a type 3 procedure. Again, remember that's from a type 2 procedure. So we are allowed to create new rules and requirements, and that's what we did for aquatic nuisance control permitting. So for something like a new application that were to come into a new lake, if I don't know, some other lake like with Salem Lake this year, if we feel it's necessary, we can require notification to more people through that same statute. That's again to get at these lakes that may not have as involved communities around them.
Yeah, so I'm hearing from the group that we're recommending that the pre-application process, that we ask applicants potentially to provide more information to the public through social media, through Front Porch Forum and Facebook pages and web pages, and working with the town health officer and the municipalities. Is that what I'm hearing from committee members? That will be a recommendation that will be added to the draft report.
Yeah, and Olin, I don't know if you included it in your section that this that it's in rule that the type 2 procedure be used for notification, but we should definitely make sure that's in the report. And then it seems to me the legislature should then consider whether that should stay in rule or become part of statute.
Yeah, I think we can add that to the report.
Great. So one other topic I wanted to bring up, because I know we discussed it prior, is the person definition. So right now, and Olin, if you wouldn't mind bringing that screen back up, under the type 3 procedures, a person is defined as any individual, partnership, company, so on and so forth. So any person can apply to and for an aquatic nuisance control permit. So this is how it's defined as now. And do we want to keep that, or does the committee members want to recommend a change in the statute if we are able to? Should that entity be a municipality? Should that be an agency? So we can review that a little bit in the report, because I did include how people can apply for aquatic nuisance control grant and aid funds. They have to be a municipality or agent of the state.
Hmm.
So we can review that, but I just wanted to call that out for the committee members, because I know that we've discussed that in the report.
Yeah, I mean, it does make sense to me that it'd be more than just one individual. And the proposals I've heard, I think, Kim, you just went through most of them. But it's interesting that if grant and aid is based on an organization and this isn't, or I know like in the land use world, like an appeal often has to be more than one person. So I think thinking about the merits of why is it one person now, and does it make sense for it to be more of an organization, or at least more than one person?
Mm-hmm. Yeah, I think the person captures the aquatic nuisance control, all of the permits, so that's why it's probably defined as such, as a person can apply for a benthic barrier because it's in front of their property. A person can apply for dash because it might be in front of their property. But I think the fact that the pesticide treatments may affect more people, so that perhaps that term should be better defined just for pesticide treatments. Okay, so I see we're a little bit over time. So does anybody have any other information about the public information notification conditions? Hearing none, we will move to the next agenda item. I also wanted to just let everyone know that Sarah's joined us. So thanks, Sarah, for being here. So I'm going to share, oh no, actually I'm not going to share my screen. I'm going to ask the committee members to open up the report draft. So you've seen, once you open that up, you can just let me know. I can actually see everybody when they're in there too. So I see Amy, Sarah, Bethany from DC is in there. So does anybody need the link sent to them of how to get into that working document? Bill, I see you're not in here yet. I see Eric.
What's the title of it?
It's in the folders. If you're in the ANC Act 57 Study Committee sorry. Hold on, I'm also, working documents. So the ANC Act 57 Study Committee is the oversight bigger folder, and then the subfolder is the working documents. So it's in working documents under working draft.
Yeah, you better send me a link. I had it before and I don't know where it went.
Sure. I think I can do that quickly.
Is that going to be an email?
Yes, sir. I just sent it.
Okay. Yeah, don't wait for me. I printed it all out this morning, so
Okay,
I can look
great.
at it in the meantime.
Brilliant. Thank you kindly. Okay. So sometimes it's a little bit easier to go under editing, open up desktop app because the formatting is quite strange in the cloud. So so you can do either or. I just have it open in the cloud, but just note that the formatting does look quite different in the document. So you see I changed around the information a little bit to make it a little bit clearer that we have. I'm just going to start at the beginning and work our way down, if that's okay with everyone. So the scope, the report highlights our affiliations, an overview that I will fill out, the dates of the meetings held and the link to the web pages. And then, as we discussed last week, we decided to put in the Title 10, Chapter 50, 10 VSA 1451, the findings for the statute for the Aquatic Nuisance Control Program. And I also included the definitions that are applicable to this, the Aquatic Nuisance Control Program, and then the permit statute, and then the additional sections. So I didn't think it was pertinent to include all those additional sections, so I just have links to those. So I can shorten this more so if you'd like me to just kind of describe them, but there's a lot of information there that's really hard to kind of summarize. I did my best. So then again, anything in blue font is a recommendation from the report. So I still have to do the overview of the history of pesticides. We are going to be talking with the Agricultural Innovation Board, which replaced the Vermont Pesticide Advisory Council. So with that change, they also have changed the responsibilities. So we're a bit unsure about how that kind of impacts the review of pesticides. So we're meeting with the Agency of Agriculture, Farm and Markets, Steve, Joanelle, and others tomorrow. Sarah and I are going to be talking with them to get better clarity about what those roles are. And how after in the past, when the VPAC approved pesticides, it came to DEC, and then we would evaluate those pesticides and look at the target species and any potential impacts, as we've discussed, at length. So then we have the breakdown of the pesticides, what impacts they may have. So Sarah's done a great job with that. Thank you, Sarah, for your help with that. And then we have the breakdown of chemicals and biological controls, the alternative practices. I am getting a cost per acre from Massachusetts. They have a wonderful graph they're going to let me use. And then the ecotoxicity. So again, we are waiting, slowly getting some of this information from our DC. It's a new division task. I don't remember what the breakdown is. Oh, and do you remember? I'm sorry that the new.
I don't remember what task stands for.
Yeah,
It used to be it's a break off of the monitoring and assessment program.
Yeah.
But I don't, it's new. It was just
Yeah.
introduced like last week, so.
Yes. So those folks are doing the ecotoxicity piece. And the public health is what Sarah has completed. The precautions that already exist and the protections that already exist and our internal review procedure. The limitations on the use of pesticides, and you can see specifically on page, where are we? On 19, which denials have been set for Lake Bomazene and a private pond. So those two Priscilla projects were denied. The potential gaps. So I guess what the standards are set as such that we have standards that are in play. We talked about getting additional standards of using those terms and better defining some of those terms that are in the statutes. So I included those. I didn't know if we needed, Sarah, this was Sarah's comment, whether we need a definition of negligibles that was necessary or whether we already had those defined terms as public health hazard, public health risk, significant public health risk as outlined in chapter 18.
Kim,
Or whether
are you on a particular page or are you?
Yeah,
just
I'm on page 21. So now I'm in the terms.
Oh, okay, potential definition. And
So do those terms look good to everyone? This is what we discussed at the last meeting. Could also comment if you'd like on the report anytime. So hearing that doesn't need to be made, so we can skip that. And then we included the public benefit and public good. And those are the conditions that are in the permit. So I believe we agreed to post those in a more public-facing manner. But again, I just wanted to call out I thought there was one for the dams. Yes, so further down on page 23, there's if you look on the comment, it brings you to the determination of public good used under dams. The committee members may use this as a foundation to further define public good. So if you would like to add comments of whether we should incorporate that as a recommendation, please do so either now or in the draft.
I thought those were helpful when we discussed them last week and went through. I thought they added a lot more detail than what's currently in the statutory conditions. So I think including them is a good idea.
The conditions as that, yep. So thank you. But not the Title 10 VSA 1086.
You mean for negligible or public health
No.
hazard?
For determination of public good.
Well, you could leave it a link, or I
Hmm.
mean, we can see how long we end up being and put it in if it makes sense.
Okay, that's a good idea. We can make, yeah, the recommendation to potentially look at adopting that potential definition from 10 VSA 1086.
Yeah.
Yeah. Okay. And so what we just outlined was a public participation at present. So we included all the information basically that Olin just reviewed. And I think we can just incorporate those recommendations that we just discussed about the application process, about social media presence, town health officers, and the application being posted or being notified in some way that to the municipalities, and whether we should change the definition of person. So I'm on page 24 now. Who can apply for an ANC permit? So there is a definition of an applicant, excuse me. And that is person. So we can make a recommendation that we potentially utilize the definition from the Aquatic Nuisance Control Grant, and I included that as a comment, so you can open that up if you want. On page 24, you'll see a comment, the grant and aid to municipalities and agencies of the state.
Yeah.
Would the committee members like to incorporate that?
I think it's a good idea.
Okay,
Uh,
consideration of including that definition. I think so as well. I think if we're going to give them grants, then we should also ensure that those are the permittees.
Kim, this is Hannah. I think we're not proposing a new definition of person. We're just revising under 1455 who can apply, right?
Correct.
Okay.
Correct. Yeah. Thanks for that clarification, Hannah. I'm glad you're here. So I see there's the comment, the statute could also require the municipality where water is located to be a co-applicant for an ANC pesticide permit. So remember, we want to put boundaries on the fact that we don't want the municipality to be overloaded with every single ANC permit.
When you say,
But how would that work with Lamperside?
Yeah, I'm not sure. Obviously, we wouldn't want to put the burden on a lake association to be the applicant. That's in the previous paragraph. It's, the applicant is the federal government, so I'm not sure if, I'm not sure. I think that's a question that should probably ask U.S. Fish and Wildlife Service.
Well, if we look at the grant and aid statute 1458A, a municipality or agency of the state that desires state assistance to control aquatic nuisances may apply in writing to the Agency of Natural Resources. So maybe
I think
if
you're
we
right.
can
That covers it.
consider that, yeah, that covers it. For herbicide or for pesticide treatments. Yeah. Okay, so I will make that recommendation.
But it
Um,
doesn't answer the question about whether the municipality should be a co-applicant
right.
for other. I mean, yeah, I don't know about for Lamperside, but I don't think I'm ready to decide on that one.
We'll try to get some text in there. So maybe I can notify you all when we kind of work through that, and maybe if you can provide some better language, and I'll talk to Hannah about that as well.
I feel like there's kind of some overlap between the who can apply and the public good determination. That there seems to be a concern that any one individual can apply for a permit, as if any one individual then automatically be granted a permit. But I think if there's a robust review of public good that includes, whether the municipality supports it, other, lakefront property owners support it, and so on, that kind of offsets this concern that we're going to have one individual going out and applying pesticide when everybody else opposes it. So I think I'm less worried about the definition of a person than I am about just having a good review of the public benefit of what's being proposed.
Yeah, that's true, Eric. You bring up a good point of the permit conditions kind of call that out.
Well, yeah, I guess the idea of having it be more than one person applies is a proxy for a larger consideration of it, right? Like it is about public engagement and planning for it.
Right. And that's a condition for the application and for the permit.
Right, although we're also identifying the flaws in that, so we gotta make
Right.
sure cover the problem we're trying to solve, which is robust public engagement in the process overall.
Exactly. Yep. So how to front load that with better education and outreach. Okay, let's see, how are we doing here? Oh, and so we're getting down to the bottom. That's great. So on page 25, public comments compilation. I believe we decided that we would put the public comments, that we're receiving lots and lots of public comments. So I hope that folks are reviewing those public comments in the folder under the ANC Act H57 Study Committee folder. There is a subfolder, which is public comments received. So how I compile all of that in the study report, I'm not sure, because we do have pages and pages of public comments that we have received. So we can, I think we decided just to include those in the appendix, and that will certainly lengthen the report. Then we should include references. I added that, and then the appendix, so which we already talked about. Okay, so does anybody have any comments, criticisms, suggestions on the report so far? Okay, I see people shaking their heads, so that's great. All right, so we'll continue working on this. Olin and I have made this our full-time responsibility, and Sarah too. Thank you, Sarah. And Eric, thanks for poking in there and looking at some of those gaps. So yeah, this has been a interesting report to develop, and I'm glad everybody's taking an eye at it and looking through it. So I appreciate everyone's help. So it is 2:15. So I believe the next agenda item, Sarah, that we added on the agenda is public comments in future meetings. So I will share my screen with what that agenda is. So public comments and future. So we just added that agenda item to get at the question whether the public will be allowed to comment in future meetings of the study committee. So I just wanted to call your attention to our timeline first before we talk about that. So the draft report developed for review by committee. On November 14th, this draft report will be finalized for review by department commissioners. So our next meeting, this report will be wrapped up in draft form and provided to department commissioners for review, for them to incorporate their comments back to us by 12/12. And then we have a short turnaround to incorporate those comments to get the report submitted by 12/15. So the next meeting, we will have this draft report finalized, and then the meeting after that will incorporate those department commissioner comments. So getting back to this public comments in future meetings, when and do you want to have public comments in the next meeting?
I think there was a request from groups, not necessarily just the public more broadly, but to
Mhm.
comment on the proposals in the draft report. And so I think it would behoove us to hear from them.
And so how do we define groups, Amy?
Well, the groups who commented last time, which were listed in the minutes, at least two of them requested an opportunity to provide feedback on a draft report.
The NRC and FOBLAP?
I think so. Again, I
Mhm.
didn't, yeah.
Yep. So do we allow them 5 minutes time?
I guess I might give them more than that, but it's up to the whole group. I would say 15 minutes. I don't know.
I think timing, I think we should think about timing. I mean, if our goal is to have the report finished by the end of our meeting on the 14th, I mean, I think public comments submitted in writing anytime before then, it would be much easier to try to incorporate that feedback into our report. I think comments at a November 14th meeting or after that, at that point where it's gone up to our commissioners. So I'm not quite sure how responsive we would be able to be at that point.
Yeah, well, I guess I'm wondering when will they have a chance to review the draft report, even the public more broadly.
I think whenever I've done a legislative report, I think it's been, whenever it's finalized, it's been put out, it becomes public at that point. Given the timeline set out in the statute for this whole process, it didn't seem to be very amenable to a lot of back and forth with public feedback and interactions.
Yeah. All right. I guess the risk is that yeah, that's fine. I guess we'll have feedback after. Then that will be potentially the same place we left off at the end of the session.
So I do think that the comments, because I receive them and I read them, that we are answering a lot of questions for the public's comments that are coming in. I've seen, the same kind of themes. And I think clarity is needed on the procedures and conditions that we have in place. And so that's, what's in our report, is that there is already a robust conditions and checks and balances and an internal procedure. There's, an external procedure. We're not so great at marketing the applications, as we just talked about, like how to get the word out better. Certainly we need to improve that. And those are the recommendations that we can make. So I do believe that we are hitting the comments. And again, if you want to review those public comments, you might find that as well.
Yeah.
Sarah, I know that you've looked at some of those public comments. Do you feel that's appropriate as well? That we're kind of incorporating some of those questions. I mean, I think the questions were already there. And so that's why we're doing this report is because you're trying to attempt to answer those questions in the report.
Yeah, I do notice that it looks like there were a couple that were added just a few hours ago. And I can connect with you offline, but it looks like at least one of them, the actual comments are not opening for me in the PDF. But yeah, I think if we want to make sure between now and the 14th that the committee members, and we can put this on our to-do list, that we all read through those comments. And, like you said, if there's anything that we can address in the report, that we make sure we get that text in so that by the next meeting, we can all look at whatever language is added and finalize that.
That's a good idea. We can make that a to-do item for the committee members by next week to review all those public comments and see if those comments are incorporated in the report in some manner, shape, or form. Eric, you have a question or comment?
Yeah, just kind of what Sarah said. One of the comments references an attachment that isn't
Mhm.
included. So
Okay,
just if you can make sure that everything's in there, I'm happy to read it over.
you bet. I will include that at the end of the meeting. Okay, so we still haven't gotten to the point of whether we are going to open up the next meeting to particular groups. I hear yes and I hear no.
I think if our goal is to get the report finalized by the 14th, I think that has to be our priority because just looking at what the time it took us to get through the report today, I'd say if we have extra time at the end, absolutely, but and just noting that, the timing may not be such that we can take those comments into our drafting at the end of the 11/14 meeting.
Mhm.
Well, I suspect we're going to hear from some of them today, and we can make sure that they submit their comments in writing as soon as possible.
Yeah, I think we've said that consistently. Oops, and I missed the develop agenda items for next meeting. So now that we have talked through that, it sounds like we're gonna continue with the same kind of agenda items of review the draft report, really. I don't think we have anything to review as far as the conditions or the permit or the statutes. I think next meeting should be review the draft discussion. Study committee report draft discussion. And public comments for 15 minutes. We make it longer. So the agenda items for next week should be welcome, approved draft meeting minutes, Act 57 ANC Study Committee report draft discussion, public comments.
I mean, I guess it's going to be discussion and approval of the draft.
That's true. And that will pretty much take up all the time. From 1 to 2. So it'll be an hour long. Okay, does everybody agree? Okay, see some shaking of heads. Great, thank you. Okay. 4 minutes left. Does anybody have any else to add about the agenda items for the next meeting? Seeing none, if the committee members are okay with that, we can open the floor to the public. He's shaking of heads, so that's what I will do. All right, is there anyone who would like to comment to the committee members? Please raise your hand. Liz, please unmute yourself. Go ahead, Liz. Hi,
Hi.
Liz.
unhide behind my my name. Yes, hello. Thank you for giving me a moment to speak today. Thanks for your time. I'm Liz Bird. I'm president of the Lake Bombazine Association. By now, I'm sure you're all really familiar with the fact that it was our application to the DEC that for Priscillacor that triggered the campaign sort of to protest and prevent our application from being approved. We really believe in the DEC. We think they did a great job, even though we don't love the outcome. I think the process is very sound and thorough. And that's why this is really important for me to be part of, because I can see it as a way to maybe make it a little more difficult for lakes that have existing permits and that have gone through a great deal of effort and expense and time as volunteer organizations to make it possible to use this as a tool in lake health. Bombazine, as you know, is 2,500 acres relatively. It's the largest lake within the confines of the state of Vermont. And, milfoil has been a concern since the 80s. Lake associations, as you know, volunteer, nonprofit. We're working hard to keep lakes healthy. And, we don't have representation by lobbyists, conservation law foundations, Vermont Natural Resources Councils, or Connecticut River Conservancy staff to support us. Those are some heavy hitting teams to get behind you when you don't want this tool to be used in Lake Bombazine. If someone yells poison at a town select board meeting and asks for resolutions of non-support, there's not a lot of resistance. That's a pretty easy get. A vote of non-support for anything that's declared to be a poison is an easy get. And no select board member wants that look. No one has the time or the energy or the desire to do a deep dive into science behind using an herbicide, when it's easier to just say, that sounds awful. I support your rejection of this idea. But in this case, the state of Vermont has done a deep dive, and an exhaustive and careful, scientifically backed deep dive. And they've offered the tool to 11 or 12 Vermont lakes to date as a safe, effective one to control milfoil. And then the current application process is complex and it's thorough. It's expensive and it's hugely time consuming for private volunteer groups, but it is based on facts and science. And I believe that to add the need for a publicity and marketing campaign to the application process has the potential to turn a scientifically fact-based process into a subjective popularity contest. And in that scenario, I believe we all lose. And I think the health of our lakes is the biggest loser. I mean, Lake Bombazine is 65 feet deep enough to enjoy if you can boat or kayak out past mats of milfoil to open water. But smaller Vermont lakes don't have that luxury. They're too shallow to find open water. They're clogged from the littoral zone straight across the center. We have an example of this condition on Lake Bombazine north of the float bridge, because what was once open water is now closed off from the rest of the lake by a concrete bridge that used to be a floating bridge. And it has created a man-made wetland. So we can sort of see what it looks like down the line when you have a smaller body of water. I listened carefully to the plan that the representative from Conservation Law Foundation laid out at the last meeting. And it seems like it's pushing and is more designed to make the application process more of a subjective, untenable, and more reliant on public opinion than science. And if you happen to live on a lake with a powerful group of protesters, you may not be able to be granted a permit. That's where it seems to be heading. And if you don't, then have at it. And those two things don't sound like an equitable, fair, or scientific approach to me. So those are my thoughts.
Thanks, Liz. Appreciate that. Next on the commenting list. So Bob, please, if you wouldn't mind, just keep your comments a little bit short because we have other people who are also lined up. Thanks, Bob. Go ahead.
Well, I'll do my best to be short. I'm sorry I've not been able to attend the last two meetings as I took my wife for a trip out west to celebrate our 50th wedding anniversary. So this is my first time here. I have been trying to keep track of what's been going on. And I just would like to say, I worked with my state rep, Seth Bongards, to introduce H31, which created this committee. During the testimony on H31, the bill was opposed by the DEC and by some of the lake associations. And now I see this group is basically being run by the DEC, which was certainly not what I thought was going to result in the passage of 831. I want to speak a little bit to the notice issue that you spoke about earlier, and that is, I believe that an applicant to use chemicals to treat a weed should have to have a public hearing prior to submitting an application. Had that happened, you would not have seen, or you probably would have seen, the massive outpouring of opposition to the application that was proposed for Lake Bomazene, and a lot of time could have been saved knowing up front what the public thought about this. I just heard from Ms. Bird saying that the public is subjective and not scientific. I would disagree with that. I think the public has the ability to be very scientific in their discussions and conclusions. The current law, the reason the whole H31 came into being is the current law is favoring a few people and is not working for the majority of the citizens of the state of Vermont. And by the way, it is the citizens of the state of Vermont that own the waters. It is not the lake associations. It is not people like myself who we should all be able to participate. I'm a little disturbed that you're doing a draft proposal and nobody's going to get a chance to see it until the end. I think that the public should be engaged in this process and right from the beginning, and we should know what you're talking about and what you're proposing and not wait until it's a fait accompli. And my effort to keep this short, I guess I would like to know, did you receive my written comments that I sent to you yesterday? And if not, let me know how I need to get them to you individually or as a group. I went on the website as best I could and sent them to the address that I had. I hope you have my written comments. I hope you have a chance to read them. The whole point of this exercise was to look at existing law and make appropriate changes so that the law works for the people of the state of Vermont and not just the lake associations. And number two, to shift our focus from number one, using toxic chemical herbicides, which if it ends in a side, it is actually a poison, to deal with a weed problem that's been in Vermont for 80 years. When there are non-chemical solutions that are available, in my comments that I've written to you, I did address the comments of a previous speaker, Mr. Conte, about the use of non-chemicals and his opposition to that. So I've already.
Thank you, Bob. I'm going to cut you off there because I did receive your comments and I just haven't been able to reply.
Did you receive my comments?
Yes, that's what I'm trying to say.
Okay,
I did receive your comments. I just haven't been able to reply back to you that I received your comments. But yes, I did indeed. And a lot of points you raised, I will mention that are in the comments. So thanks very much. We have a couple more people. So I believe, Pat, you're next on the list. So please keep your comments brief.
Thank you, Kim.
Thanks, Pat.
Thank you, everyone on the committee. I will keep it brief. Just a few reminders. I just want to call the committee's attention to statutes, as Bob just mentioned. Statutes 10 VSA 1451 does require the state of Vermont, which does hold the public waters in trust for the citizens of Vermont, to prevent infestation of invasives or to reduce infestation should they exist. That means the state is required to not turn a blind eye to these infestations. And it doesn't matter whether the infestation is brand new or whether it's been in the state for X number of years. An invasive is still an invasive. It still harms the aquatic environment, and it's important to recognize that. In terms of public comments, I just want to add, and I've said this before, the concern is that these decisions should be made based on evidence and data. And while, input is important, to carry for a comment that suggests that something like Procellacor kills everything in the lake, and this is a comment that's been made by members of the public, is simply, there's no evidence presented of that. And all the evidence we have is that it actually does not, that it's very narrowly targeted. So I think it's really important when you think about public input to consider the fact that this needs to be science-based, because our top priority has to be to protect the aquatic environment, to protect our environment overall. And that includes anything that's being used, whether it's lampricide, whether it's dealing with invasive milfoil, or it's dealing with terrestrial invasives like buckthorn and so forth. So I want to say that, and I have one last thing to say, is I hope the committee will take into consideration the time, the complexity, the costs of doing this work. And this work is mostly done with the advice of these scientists in DEC and in the state, but it is mostly done by lake associations. So the lake associations are carrying out what is statutorily required by the state, and they do it under the guidance of the state. Lake associations aren't out there making this up. And I think that's really important to remember when considering this. And it is very complex, and lake associations raise the funds to do it. The state provides very little, if any, funding for this. So just want to add those in. Thank you. Thanks for your time.
Thanks, Pat. Jared.
Good afternoon. Great to see you all. Just one moment.
You're echoing, so if you wouldn't, oops.
Is that better?
Yes, thank you.
Oh, can you hear me all? I think, hang on.
Yes, we can hear you.
Yeah, okay, sorry. So I just wanted to note two things. One, comment was put in the chat. The BNRC and the coalition partners will file more extensive comments sometime next week to be incorporated. And then I would ask a suggestion that on November the 14th, when the committee, when the study group finalizes the report and sends it to the department commissioners for their review, that it would also be released to the public. And then the public could comment on the draft report, and those could be incorporated by the department commissioners on the December 12th date before it is sent to the legislature on December the 15th. That way the public would be able to make comments on the report and then be incorporated and sent along, since the public has not had an opportunity to view the report and otherwise would not until it was released to the committee, the legislative committee. So just a suggestion. And that's all my comments. Everything else will be in writing.
Thanks for that comment. I will. All righty. So let's see, we have 4 more minutes left. So I will put together the agenda items as we've already agreed upon, and write up the meeting minutes, continue working on the draft. So if folks can look at the draft in a week's time, since we're not meeting next week, if you can all be sure to read through the draft, incorporate any comments that you have, especially with the language that we're considering changing a little bit, and making those recommendations. I would appreciate it by next Tuesday. So does everybody have time to look through this draft by next Tuesday and make comments?
So the next meeting's in 2 weeks.
Yes, but I'm asking that if you can incorporate any, new information or anything, or be sure to read through the public comments to incorporate any public comments that have come in and incorporate those into the report, as we just discussed, by potentially next week. And if you incorporate those changes, then we can have a discussion kind of in the draft report to each other about, how those incorporations were included, or we can comment on those. So, the working draft is a way to dialogue and correspond as well. I just want to make sure that everybody understands that. So if we can incorporate some comments, discussions, what have you, in the report, then we have a week's time to consider those as well.
Okay, so you're mentioning if we all comment, and then we still have time before the next meeting to respond to comments.
Mm-hmm.
Okay.
So I'll be sure to include any public comments I have so far in the working documents, including the one I didn't include I included the email message, but not the comments. So I just received that one today. Sarah's mentioning she will be out of the office 11:06 to 11:10, so I won't be able to work on the report that week. That's fine, Sarah. I think you've done a lot to date, so perhaps after when you get back, you can check that out. Okay, I think Sarah, are you still here?
Yes, I am still
Oh,
here.
Okay, I just didn't see you. Okay, great. Okay, so does anybody have any comments? Any members have any comments? Questions? Okay.
Just one thought. I know we've got a couple folks that weren't able to join us today, like Ellen Marsden and Chris Bray, and might be good to just reach out to them and let them know what we just talked about now, as far as having them review the report and get comments in.
Great, thank you for
They
reminding me.
might not be all that quick to read the meeting minutes.
Yeah, thank you. Good suggestion, appreciate that. Yeah, and just so you're aware, again, I put up the meeting minutes and the agenda in the working documents as well. So if you want to review those, they're available for committee members to review and comment on as well. Okay, well, I believe it's 2:45. So if it's okay with members, I believe we can adjourn. Thank you all. Thank you, Olin, for your presentation. Appreciate it. Thank you. Thanks, everyone. The meeting is adjourned. Bye-bye.